We left off talking about the case of the promoter who entered into a contract before the corporation was formed. And what do you do? And the answer is that if the lease agreement or the contract, whatever it is entered into in the name of the corporation, before it is formed, when there is no corporation, then the promoter is liable. So let's put that up. So if the contract is in the name of the corporation, then the promoter is liable. And please notice that the promoter is liable, but if the corporation, after this contract has been created, let's say that a promoter contracts to buy space, to rent space for the corporation, and does it before the corporation comes into existence, and then signs it, like we did over here. And then signs it here before the corporation has existed. So you sign it Joe. If you do this, it doesn't matter. I'm not trying to put the name promoter here. It doesn't matter. I'm saying Joe is the promoter. So if you do what you see here on the top half of the board, the promoter is liable. But even if you, right now, let's leave this part off because we're doing this in two steps. Leaving this part off for the first step. And the contract now says, I lease this space to the X corporation, signed Joe. And Joe is a promoter. In this case, Joe will be liable. Because this is the case where the contract is formed in the name of the corporation. Take a look. That's this case, where the contract is formed in the name of the corporation, promoter is liable. Now, after the corporation is formed, and the corporation now decides, yeah, this is great office space, let's use it. So the corporation starts using the office space. Well, that is probably adopting the contract. That is to say, one way the corporation can adopt the contract is they can have a board of directors meeting, and this contract that Joe signed is now presented to the board of directors, and they say, yes, we like this contract, we will adopt it. So now the corporation has adopted the contract. But that really kind of amounts to Joe delegating his duties and assigning his rights under the lease to the corporation. So it's really a delegation of duties and assignment of rights from Joe to the corporation. We call it just adopting the contract. But so if the corporation votes and says we adopt it, then the corporation is now liable because they expressly adopted it. But Joe remains liable because if Joe was liable at first, you don't get out of your liability just by delegating your duties to somebody else. The delegator remains liable. So in this case, where X enters in the name of the corporation, the promoter is liable, and the corporation is liable if they adopt it. And there are two ways the corporation can adopt. One is they can expressly adopt, by holding a meeting and saying we adopt it, and the other is that the corporation can impliedly adopt, and the corporation impliedly adopts the contract if they accept the benefit of the contract knowing that it exists. If the corporation knows about the existence of the contract and they accept the benefits, that is impliedly adopting the contract. So even in the case of the implied adoption, the corporation may become liable, but Joe is still liable also. If Joe wants to become unliable, we would need an ovation. You need an ovation to terminate the promoter's liability. An ovation, as you know, is where all three parties get together and they agree to replace Joe with the corporation. So this is a case where the corporation is named in the agreement, but it doesn't exist, and the promoter signs it. Promoter's liable, corporation becomes liable when they adopt it. The promoter becomes unliable if there's an ovation, otherwise promoter continues to be liable. The next case we want to cover is the case where the corporation, the contract is entered into not just in the name of the corporation, but it's entered into where you tell, where you literally tell I lease the corporation, I lease the space, I lease the space to X corporation to be formed. So now we have a different situation because the liability in these pre-incorporation contracts really turns on the intent. Put that in your answer. Turns on the intent of the parties. The lessor in my lease case must have intended to lease to the promoter because if the corporation, the lessor thought, well, I'm leasing to somebody. If I'm leasing to somebody and the corporation doesn't exist, then I must be leasing to the promoter. So in order to protect the innocent lessor in this situation, the courts will say that the promoter is liable. So that's the easy one. That's the case we just went through. But since these cases really turn on the intent of the parties, here's a case where the lessor knows that the corporation does not exist. And so how can the lessor believe that he or she is leasing to a corporation when they know it doesn't exist? So you have a pretty good argument in this case that the parties, the lessor did not intend to lease to Joe. And you can, but it's debatable. Courts will go both ways on this. Now, if Joe signs just as Joe, as I have it here, but let me do this to sign Joe, president. So now, even though the lessor knows that the corporation doesn't exist, they know that it's going to be formed and Joe is going to be president. Who are they leasing to in this case? And the answer is you don't have to know so much because the cases go both ways. What you have to do is to try to determine the intent, particularly the intent of the person who's about to be a victim, the intent of the lessor. So if it looks like the lessor really wanted to deal only with the corporation, then the promoter is home free. But if there's ambiguity about what was the lessor's intent, then the promoter will be liable. And that's how these work. Now, so far we have two things that have happened during the formation of the corporation. We have the pre-incorporation subscription agreement, and we know how those work. And we have contracts, actual contracts to lease space, or contracts to employ people, contracts to buy things. Any of these kinds of contracts, the promoter may be liable, and most of the time the promoter is liable. But if you can show what the intent of the parties was clearly enough, and that the lessors or the person in that person's position really intended to deal with the corporation, then only the corporation will be liable. Otherwise, they both will be. The promoter is liable, and the corporation is liable if they adopt it. Now, so we are at the point then where the promoter has raised money, pre-incorporation subscription agreement. Promoter may have entered into some contracts. Maybe they entered into them on behalf of the corporation. Start out assuming the promoter is liable. Get him out of it if you can show enough intent for the lessor to deal really with, or whoever is in the lessor's position, to deal with the corporation. There's one case, for example, where the person who was selling some stuff to the corporation, some widgets to the corporation, and the person selling the things to the corporation insisted that even though the corporation was not formed yet, knew who the president and secretary was going to be, and said, I want to deal with you want these people to sign as president, and made the contract to sell these widgets to the corporation. And so given all of that by the person selling to the corporation, wanting them to name the corporation as the other party, wanting them to sign as officers of the corporation, you can make a very good argument now that this person selling this stuff really wanted to deal with the corporation, not with the individual. And so if you got that kind of evidence, then that gets rid of the individual's liability. Now, so now that we've got all this done, the next thing we want to do is to form the corporation. And I mentioned to you that for the promoter to form the corporation, for the promoter to form the corporation, you need the promoter to file the articles of incorporation with the Secretary of State. And those articles, what do they have to have in them? Well, the articles need to have things, just a few mandatory things. They need, of course, to have the name of the corporation. Secondly, you need to identify who the incorporators are, who are the people who are forming this corporation. It can be one or several. Third, you need to say how many shares you're going to issue, of stock you're going to issue. Those are the mandatory requirements. Now, there are certain other requirements that are not mandatory, directory requirements. For example, you need to file a set of articles. You need articles for things. So the things you need are, number one, name of the corporation, how much stock you're selling, who the people are that are incorporating, and you need to file it with the Secretary of State. Now, if you have complied with these, those are the mandatory requirements. It used to be that you also had to say what business the corporation was going to engage in. But nowadays you can do that very broadly, that any business, any lawful business will do. There are other requirements that are not mandatory. They're called directory requirements. They're secondary. They won't prevent you from forming the corporation. For example, in every county where you're going to do business, you need to file a set of these articles. You need to identify the person who can be served for process. If you want to sue the corporation, what person do you name? Who do you serve? Those kinds of things are pretty secondary, and they don't keep you from forming the corporation. Now, So let's move on then. We have formed a corporation. We've dealt with contracts for money. We've dealt with contracts for services or goods. And now things, the corporation is formed, and you now get your very first corporate meeting. At this very first meeting, there are certain things that happen. Let's suppose, for example, that there were 5 incorporators. At this first meeting, when they meet for the first time, these 5 incorporators act like the board of directors. They run the corporation for the first year, if you need to. They can run it for up to the first year, and then at the end of the first year, you must have an election of the board. The shareholders must have an election, and they can then decide who they want to be their directors for the next year. But you must have an election by the end of the first year. Now, these 5 people who are the incorporators, in effect, are the directors until you replace them with incorporators. And the way you normally replace them with incorporators is that the articles of incorporation will say how many directors you're going to have. It'll say how many directors, and then I will also say that if someone leaves office during the term, that the remaining directors have the authority to appoint someone to replace them. It might say that, and it might not. It might say that you can call a special election. But they normally say that the people who are there can replace them if they want to. So in that case, let's say that incorporator number 1 says, I resign. So this person resigns, and now you've got 4 other incorporators left, and they say, well, we want to replace them. And we're going to replace this person with a real party in interest. The incorporators are often not the real party in interest. The incorporators are often just some partners at the law firm who were just doing all the paperwork to get the corporation formed. And once it's formed, these partners at the law firm aren't the real parties of interest. So one of them says, I resign, so this person leaves and says, okay, the other 4, we will replace that person with one of the real parties in interest. So you bring in the real parties. Now you got 5 people again. The second law partner, or whoever the person is that's standing in, that's not a real party's interest, the second person says, I resign. And now you only got 4 people, but these 4 people say, okay, we'll replace them with the real party in interest number 2. So you go through this until all of the real parties in interest have now replaced the incorporators. Now, of course, the people who are the incorporators can be the real parties in interest. But if they're not the real parties in interest, they get replaced in that way. If they are the real parties in interest, they can run the business for the first year until the first election. So now, with all that in mind, let's look at a problem. Let's look at the problem from the February 1980 bar. If you look at the problem from the February 1980 bar, you'll see an opportunity to use a lot of the stuff that we were just talking about. In the February 1980 bar, the question reads as follows. Gill entered into a written contract in State X with Ted in which it was agreed that Ted would be paid $5,000 for his services as a jewelry salesman for 6 months, commencing 3 weeks later, quote, on behalf of Jelco, a corporation to be formed. On behalf of Jelco, a corporation to be formed. And it's signed by Gill, quote, by Gill on behalf of a corporation to be formed. And so we see that Gill is entering into an employment contract with Ted, where Ted is going to work for 6 months for $5,000 for the Jelco corporation to be formed. Well, that's fine. We know about that sort of thing. If you ask the question, is Gill liable Well, normally Gil, the promoter, will be liable. But if you can make a strong enough case claiming that Ted really wanted to deal with the corporation, not with Gil, and in that case, then Gil is not bound. Well, here it does say that Ted is to work for the corporation to be formed, and so the trouble is that allows, that means that Ted knows the corporation does not exist yet, so he cannot be contracting with the corporation. So it looks like Gil because of that. He also says that Ted is to start to work in 3 weeks. Well, that with a fixed date like that to start to work, it almost looks like Ted is supposed to start to work in 3 weeks, whether the corporation has been formed at that time or not. So you can see that there's some evidence each way. You're looking for Ted's intent. That's the big thing. And the factors we have so far regarding Ted's intent are, number one, that Ted knows the corporation does not exist. So it's hard to say that Ted thought he was dealing with a corporation. The second thing is that Ted is supposed to start to work in 3 weeks, whether the corporation is formed or not. So that looks like maybe he wasn't intending to deal exclusively with the corporation. On the other hand, so we have corporation to be formed, starts in 6 weeks and 3 weeks. Gil signs on behalf of the. So you're looking for the intent, looking for the intent of Ted. Who did Ted think he was working for? Obviously, they put it down the middle, so there's some arguments on both sides. Give them those arguments, and then conclude that, unless we can be fairly sure that Ted only wanted to deal with the corporation, that Gil will be liable. Now, of course, if the corporation adopts this sales contract, then the corporation will become liable by adopting it. But until then, it looks like it's Gil. Also, so let us continue. Second paragraph. A week later, Gil, Art, and Bob met and orally agreed to pay $3,000 each for all of the stock of the Jelco Corporation. So Gil, Art, and Bob met and orally agreed to pay $3,000 each for all the stock. Now, so this is a pre-incorporation subscription agreement. People agreeing to buy the stock. That's the pre-incorporation subscription agreement right here. It says we'll agree to buy all the stock of the corporation for a certain price. Now, if Art, Bob, or Gil, if either one of them, doesn't want to honor this contract, can you get them out of it? Well, you can get them out of it if you have any of the usual contract offenses: fraud, statute of fraud, duress, unconscionability, lack of capacity, mistake, any of those things are regular contract offenses. Plus, there are 3 special ones that apply over here to corporations. If this jewelry sales corporation materially changes its purpose, they didn't in this problem. Was the stock fully subscribed? Well, it looks like it, because the sentence we just read says Art, Bob, and Gil orally agreed to pay $3,000 each for all of the stock. So it doesn't look like there's any unsold stock, and so you can't get out of the contract on item 1 or 2. And number 3, is this a de jure corporation? Well, we don't know about the formation process. We'll take a look at that. Continuing, Art, Bob, and Gil agreed, met and orally agreed. Notice it's orally agreed. So the bar examiner has told you that they orally agreed. That means that this agreement doesn't satisfy the statute of frauds at this point. And If this is a contract that must be in writing, well, we haven't satisfied the statute of frauds. It's not in writing yet. In the normal contracts that must be in writing to satisfy the statute of frauds, we have sale of land, sale of goods for goods, not stock, for the price of $500 or more. Contracts in contemplation of marriage must be in writing to be enforced. Contracts which cannot be performed within 1 year of the date they're made must be in writing in order to be enforceable. The contracts to convey an interest in land must be in writing in order to be enforceable. The contracts to promises to pay for the debts of another must be in writing. So all this statute of fraud stuff, in case you have forgotten, the common law list of the situations where you need a writing in order for it to be enforceable. You recall my legs is the mnemonic statute of frauds. Help remember all the situations where the common law required that the contract must be in writing. To M, contracts in contemplation of marriage. Y, year, contracts which by its own terms cannot be performed within 1 year. This is marriage. This is year. This is land. Contracts where you promise to convey an interest in land. If that interest in land is to last for more than 1 year, the contract must be written. This is, by the way, different from a deed. The deed is not the contract to convey an interest in land. It is the conveyance if you deliver the deed. But the contract where you promise to sell the land for a certain price, that's the contract we're talking about here. Okay? And that must be in writing. The executor of an estate, if someone died and you are the executor of the estate and you enter into contract on behalf of the estate. Remember, when people die, that their property they own is suddenly owned by that person's estate. An estate is another one of these artificial entities, like a corporation is an artificial entity. A trust is an artificial entity. Well, an estate is an artificial entity that owns the property of people who just died until you get it distributed to the people who really belong. Someone has to run that estate. That person is called the executor or the administrator. Contracts on behalf of the estate must be in writing. G, guaranteeing debts of another, and then the sale of goods for $500 or more. Must be in writing. This is guaranteeing debts of another. So in this list of common law transactions where you need a writing, the sale of stock is not among them. And so ordinarily we don't have a writing requirement for a contract to sell stock. Actually, there is a statutory one. You'll see that statute later on. But it's not among the common law requirements. Continuing, it says before anything further was done, Art and Bob wrote to Gill, stating, they, quote, "We hereby revoke any agreement to subscribe to the stock of any corporation to be formed by Gill." So they just wrote a letter to Gill saying, we don't want to buy it anymore. Well, can they get out of it? Here, they got to qualify under one of these three reasons to get out of it. They're saying we don't want to buy it anymore. 1 and 2 won't work. 3, de jure corporation, we haven't looked at the formation process yet, so we don't know about that. Continuing in that second paragraph, Gil wrote back. Oh, and by the way, when they wrote this letter, when Art and Bob wrote this letter to Gil saying, we hereby revoke this agreement, that letter itself is probably enough to satisfy the statute of frauds. Later on, there's going to be a little statute of frauds. It's not a common law, it's a statutory one. But if I say, I offer to buy your car orally over the telephone, I offer to buy your car for $10,000, and you answer saying, fine, it's a deal. We got a contract. Well, now we have an oral contract where I'm supposed to buy your car for $10,000. But the problem is that that's not enforceable because it's a contract for the sale of goods for $500 or more, and we need a writing, and we don't have one. Well, if I write you a letter and I say, dear you, this is to let you know that the contract that we just entered into on the telephone yesterday, where I'm supposed to buy your car for $10,000, or I guess you were buying mine, for $10,000, that contract is, I don't want it anymore, and I'm not going to sell you my car. Signed, Emerson. Well, if I write you that letter is enough proof, written proof, that we have the contract. And so if I do that, you now have satisfied the statute of frauds by using that writing. Whereas if I wrote you a letter and it wasn't that clear, I wrote the letter and saying, no deal, signed Emerson. Well, the writing does not identify the goods. It doesn't give the price. It doesn't say the subject matter. It doesn't do any of that stuff. If I just write you and say no deal. So if I write you a letter and saying, I refuse to sell you my car for the $10,000 we talked about yesterday on the telephone, even though that was a good contract, signed Emerson, then we now have a writing. So be careful how you deny things. You may end up satisfying the statute of frauds if you're not careful. So we're now at the point where Art and Bob wrote this letter to Gil saying, we don't want to do it anymore. But they, in this letter, if you remember the statute of frauds, what you need is to include the parties, price, subject matter, and time for performance. If I have a writing, and the writing is going to satisfy the statute of frauds, that writing needs to include parties, price, subject matter, time for performance, and quantity also, if it's goods. Parties, price, quantity, subject matter, time for performance. That's what you need in writing. Now this letter, I just said to you, this letter might satisfy the statute of frauds as to Art and Bob. Well, let's see. This letter identifies the parties, Art and Bob and Gil. The letter is probably signed, since letters are usually signed. It identifies the subject matter. It says the stock of this corporation to be formed by Gil. That's good enough for the subject matter. The price is not here in writing. Oh, it's a problem, because you need the price in writing to satisfy the statute of frauds. Also, the quantity needs to be in writing, and the quantity is not here. So although this is a writing, which you can try to use to satisfy the statute of frauds, it identifies the parties, the subject matter, and time for performance isn't all that critical anyway, but it does not identify the price or the quantity. So it probably won't quite satisfy the statute of frauds. Continuing. Gil wrote back to Art and Bob stating that it was impossible to rescind. And so Gil is treating it as though he already has a contract. If you rescind contracts that exist, you revoke offers, but you rescind contracts. So Art and Bob are saying, you look at their language, they're saying, we hereby revoke our offer to buy that stock. So they're looking like just a continuing offer. And Gil says, it is impossible to rescind. Well, Gil is treating it like it's a contract already, and somebody wants to rescind it. So Gil thinks they already have a contract. Do they? Well, they don't have a contract with the corporation yet. They don't have a contract with Jelco because it doesn't even exist. Do they have a contract with Gil? Well, I don't know. It says Art, Bob, and Gil agreed to buy this stock. Well, they don't have a contract with the corporation. This is a mere offer. But you know what? They might have a contract with each other. Because if three of us in the room, and I say, look, I will donate $10,000 to the Red Cross if you will donate $2,000, $10,000, and I say that to each of you, and each one of you, other two people in the room say the same thing, they'll donate $10,000 to the Red Cross if I do. Well, we have each made promises in consideration of the promises of others. We have a contract with each other. If I donate $10,000 to the Red Cross, you've got to do it also, because that's our agreement with each other. Now, so far as the Red Cross is concerned, okay, as far as the Red Cross is concerned, they are the donee, and so if they are the third party beneficiary of the contract that we have with each other, third party beneficiary. And if we put that contract in writing, we put the contract with each other in writing, and the Red Cross is the third party beneficiary, they should be able to enforce that. Because the contract's in writing, they're the third party beneficiary, and so they should be able to enforce it. Now here, Art, Gil, and Bob agreed with each other to pay $3,000 each for the stock. Did they agree with each other? Is that what happened here? Do they have a separate contract with each other? Well, the language says Art, Bob, and Gil met and orally agreed to do this. So they seem to have agreed with each other. So there is a possibility that there's a real contract here, because if they agreed with each other, that forms a contract. If you had the writing, then Gelco, the corporation, could say we are third-party beneficiaries. But they don't have enough writing to satisfy the statute of frauds. Keep going. Third paragraph. Gil immediately prepared the articles of incorporation, naming himself, Carl, and Dan as the initial incorporators. Well, that's fine. You can name any people you want to. He's named these three people as the initial incorporators: Gil, Carl, and Dan. Now notice that Carl and Dan are not buying any stock. They didn't promise to buy any stock. But you can be a director without owning any stock. So we now have the three incorporators, and he has filed the articles. Next sentence. However, in his haste, Gil failed to set forth the purposes of the corporation as required by state law. Now, historically, you had to put in your articles what the purpose of the corporation was. Modernly, we know you don't have to fill it out. All you have to do is to say we intend to engage in any lawful business. But this says the state law says you have to identify the purpose. And if that's a mandatory provision, then they have not complied with one of the mandatory provisions. And this is not going to be a de jure corporation. If, on the other hand, identifying the purpose of the corporation is not a mandatory provision, but a mere directory provision, then they should have done it, but it won't stop them from forming a de jure corporation. So they may or may not have a de jure corporation, depending on whether stating the purpose is mandatory or not. Continuing, it says, despite this omission, a charter was issued to Gelco by State X after the articles were filed. Well, if State X issued the charter anyway, okay, if they issued a charter anyway, in spite of leaving something out, most courts will say, well, that's it. You've got a corporation because the state issued the charter. Now, if there's a mistake, the state should not have issued the charter. What the state can do is the state can communicate with the directors and say, look, we issued the charter. There's something wrong that you didn't include in your filing, and if you don't fix it, you send us the information we need to correct this. If you don't fix that, we're going to de-incorporate you. We're going to revoke your charter. And that's called a quo warranto quo warranto proceeding where the state basically says we're going to revoke your charter if you don't fix it. So it looks to us like they have a corporation, probably a de jure corporation. It might have been de facto, but since the state issued the charter, the general rule is that it is now de jure, but the state can make you, in fact, I'll take it back. It's not de jure, it's de facto. In this case where there's something missing and the state says, if you don't fix it, we're going to de-incorporate you. Well, while you're waiting to fix that, your corporation, again, is called a de facto corporation. It's not de facto based on these three requirements that we talked about before, but it's the state, it's de facto based on the fact that you left something out and the state can de-incorporate you. So that's where we are at this point. We now have a de facto or a de jure corporation, one or the other. Again, if the state issues the charter, then you are a corporation, normally de jure. But if there's something wrong, you're de facto until you fix it for the state. That de facto corporation is just as good as a regular one for all purposes except the state itself. They can make you fix that. Next paragraph. Gil, Carl, and Dan then held the initial incorporators meeting. We know about that meeting. That's when the one we told about. And these people, the initial incorporators will keep acting as the directors for the first year if you don't replace them. Gil, Carl, and Dan then held the initial incorporators meeting for Jelco in accordance with the State X law, and they were duly elected as Jelco directors. Okay, so they now are the directors. No problem. You got 3 directors, 2 of whom don't own any stock, and Gil does. By unanimous vote, the 3 directors then accepted the stock subscriptions of Gil, Art, and Dan. That's fine. You now have a contract between Gil, Art, and Dan and the Jelco Corporation. Gil paid his $3,000. That's fine. Gil should have. So the corporation got $3,000. Art and Bob refused to pay or to participate in any business. Well, can the corporation make Art and Bob pay? And the answer is, well, if they have an enforceable contract, yes. But Art and Bob are going to say that you can't make us pay because you don't have a de jure corporation. Remember that these are besides the regular contract offenses, they have these. Art and Bob cannot say that there's been a material change in purpose. They cannot say that the stock was not fully subscribed because all of it was bought. But they can say that you're not a de jure corporation because you're not. They're de facto because the state law says you got to have a purpose in there, and they didn't put the purpose in, and until they do, they are de facto. Only the state can do anything about it, but they're still de facto until that time. So the Art and Bob have this excuse for not paying the money. Plus, as you will see in just a few minutes, the contract, the pre-incorporation subscription contract, this one, must be in writing, because they're going to tell us that in a few minutes. And this pre-incorporation subscription agreement is not in writing, but you do have the letter that would satisfy the statute of frauds if it had all the elements in there. It identifies the parties, the letter that Art and Bob wrote to Gil. It identifies the parties. It identifies the stock, but it doesn't have a price and quantity, so even that letter won't quite do it. Continuing, last paragraph. Ted worked in the jewelry sales business for Jelco for 3 months without knowledge of any of the events occurring after his execution of the contract. Well, even if Ted made his contract with Gil and not with the corporation, if the corporation didn't exist, so Ted could not possibly have made an employment contract with the corporation. He made it with Gil. But since he worked there for 3 months and the corporation accepted the benefits of his labor, then we may have the implied adoption. You recall that a corporation can be liable by adopting a contract. They can expressly adopt it, or they can impliedly adopt it. And in this case, you impliedly adopt a contract if the corporation knows it exists and accepts the benefits. Well, here's a case where the corporation knows about this contract with Ted because Gil negotiated, and Gil's a director. And if you tell one director, of course the corporation knows. So the corporation knows about this contract because Gil knows. And secondly, since Ted worked there for 3 months, I don't know how much jewelry he sold, but he's there trying. So the corporation is accepting the benefits of his work while knowing about the contract that amounts to an implied adoption. So the corporation has adopted the contract. Even if the corporation has not adopted the contract, if they accept the benefits of Ted's labor, they're going to have to pay him quasi contract for whatever he did. But they don't have to, it's not a full contract now. Continuing, the last sentence in the problem says, when Ted inquired about his compensation, inquired about his compensation, he discovered that Gil had disappeared and Jelko refused to honor the contract. Well, Jelko has probably impliedly adopted the contract, so he should be able to get paid. But even if they have not impliedly adopted the contract, he's worked there for 3 months, and they got to pay him something for the 3 months. They pay him quasi-contract for the 3 months. So now let's look and see what we have. Next line. A statute of State X provides as follows. A contract for the sale of securities is not enforceable unless there is some writing signed by the party against whom enforcement is sought. There's your statute of frauds. So this contract between Art and Gil and Bob, where they're supposed to buy stock, is not enforceable if it's oral. And it started out oral, but Art and Bob wrote a letter which they signed, and that letter was almost enough to satisfy the statute of frauds. But the letter didn't quite satisfy because it doesn't have the quantity or the price. And so the contract is not in 3 reasons why the contract between Art and Bob, why Jelko cannot compel Art and Bob to pay up. The contract, Art and Bob, over here, we look for these 3 special defenses that apply to corporations only, and we've got the third one. This is not a de jure corporation. It's not de jure because the state has the right to revoke the charter if these people don't put the purpose in there like the law requires. So it's still de facto. That may get them out of it. And secondly, the statute of fraud is not satisfied, and that will keep Art and Bob from having to pay. So that's where we stand. Let's look at the call to the question number 1. What are Ted's rights against Jelko? Well, Ted's rights against Jelko, if Jelko has impliedly adopted the contract, he's got a 6-month contract with him. If Jelko has not impliedly adopted the contract, Ted is still entitled to quasi-contract for 3 months' work. Second call to the question. What are Ted's rights against Carl and Dan? What are Ted's rights against Carl and Dan? Well, Carl and Dan, Ted is the employee or somebody who seems to have a contract with Jelko, or at least working for him, and Carl and Dan are simply directors. Well, the directors are not liable for the debts of the corporation. The corporation is liable for its own debts. And Carl and Dan are not liable for the debts of the corporation. So Ted can get nothing from Carl and Dan. Finally, are Art and Bob bound by the $3,000 agreement? The answer is no, for two reasons. That they're not bound by the $3,000 agreement because, number one, statute of frauds, not quite satisfied, and number two, they can get out of it on the basis of this number three here. It's not a de jure corporation because the state law says you got to put the purpose in, and when they didn't put the purpose in, then the state says this is still a de facto corporation until you people fix it. And that's the answer to that problem. You can see how this problem deals with that front-end problem of creating a corporation, making contracts, promoter making contracts before the corporation is formed. And here the promoter made two kinds of contracts. Promoter raised money by using pre-incorporation subscription agreements, and the promoter also made a contract with a prospective employee, namely Ted. That takes care of this question. When we come back at the end of the break, we will look at the next question that we're going to use for today, and that's from the February 99 question. So if you take a look at that, we'll come back at 12 minutes.